And you can see that much of the rule is kind of mechanical, that the rule must be in writing unless the court permits it to be made orally. The motion has to state the time and place when it's going to be presented to the courts, the grounds upon which it is made, and the nature of the relief sought. These are kind of standard things that you should be including in every motion. Now, the rule also requires that the order has to note whether or not the motion was opposed or unopposed. And if the motion or response relies on facts that are not in the record, you have to support it by affidavit. Motion shall be deemed to be uncontested, and there will be no right to argue orally in opposition unless responsive papers are timely filed. Now, all these things apply generally to all the courts, but in particular, it can apply to municipal court. Now, municipal court has its own specific rules related to motion practice, and there's two of them that I'd like to bring to your attention. First is 771, and this sets forth that pleadings in municipal court consist only of the complaint. A defense or objection capable of determination without trial of the general issue shall be raised before trial by motion to dismiss or for other appropriate relief, except the motion dismissed upon lack of jurisdiction or constitutionality of a municipal ordinance, which can be made at any time. Well, so when the rule was drafted, basically they left out attacks on the constitutionality of a statute purposely. So if you're going to raise defense of this, as to the constitutionality of a statute, that motion has to be brought in the Superior Court. That's number one. Number two, by statute, the Attorney General has to be placed on notice. The Attorney General becomes a party in any application that you're making to challenge a statute. So say, for example, it's harassment. You were going to challenge the constitutionality of the harassment statute. That motion would be in the Superior Court. You would put the Attorney General on notice as well as the municipal prosecutor, and then go up there and slug it out in the Superior Court. However, if the attack is on the constitutionality of an ordinance, that can properly be done in the municipal court. Notice also that when there's an application to dismiss something based upon lack of jurisdiction, that can be done at any time, meaning before the trial, during the trial, or as we'll be talking about in a little while, after the trial. The specifics about actually making the motion in the municipal court is under Rule 7:7-2. And this rule was subject to a lot of controversy when it was adopted back in 1998. So A, how made. Motions in municipal court and answers to motions, if any, shall be made orally. So that's where your starting point is, that the expectation in the rule is that the normal run-of-the-mill motion is going to be made orally, unless the court directs that the motion and answer be in writing. Oral testimony or affidavits in support or opposition of the motion may be required by the court in its discretion. Now, just because the court rule says that these motions should be made orally, unless the court orders otherwise, should not give you license, especially in a case that has any kind of complication to it, to think that the appropriate way to approach it is just to have an oral motion. And we're going to take a look at the case law that interprets that in a couple of seconds. My sense is that unless it's something very, very simple, your motion should be really filed in a professional manner. In writing, with supporting affidavits or whatever evidence you have to have, with a form of order, so that the judge can fairly decide the thing and that your adversary can be placed on notice as to what you're talking about. The hearing on the motion made before trial shall be determined before trial unless the court in the interest of justice directs it be heard during or after trial. This is to really kind of get all the issues that have to be decided by way of motion done prior to trial, so that the trial, the matter is not going to be interrupted by some type of extraneous motion that should have been handled ahead of time. Now, we've talked about HOP a couple of times, and I've given you, I don't know if I gave you the whole case, but I certainly want to call your attention to the last page of HOP. This case is getting some whiskers on it now. It's a 1992 decision. I remember it came out 2 days ago, but for some of the younger attorneys in the room, this is an enormously important case that if you weren't aware of it before, you should be aware of it now. Think of the enormous changes in municipal court practice in terms of the added responsibility with motions to suppress evidence in domestic violence cases and, school zone drunk driving cases and all that since that time. We are constrained to comment on the effect of 742, which is the predecessor rule to the one we just discussed, which permits motions in municipal courts to be made orally and informally. As our municipal courts mature and become more responsible for the disposition of more complex, more serious in terms of penal consequences, and more communally important cases, this is presaging everything that happened since that time, more formal practices become essential. We understand that much of the subject matter and controversy in municipal courts is minor, and in such cases, informal practices should continue. But in more significant cases, a more careful, thorough procedure is warranted. There is a recognizable difference in the analysis of discovery in a drunk driving case as compared to one involving a stoplight violation. The mere fact that the court rule allows informality does not give broad license to counsel. Motions and supporting documents assist the municipal court judge in making a fair and considered decision. A motion limiting the time for completion of discovery in this case would have ensured notice to the prosecutor and avoided the waste of time by the defendant, an expert witness, and defense counsel. So, if you are in a situation where there's some issue that has a certain level of complexity, and someone tries to drop a bomb on you in court with some type of oral motion, the first thing you should do is say, listen, this is something that should have been done. Notwithstanding the court rule, this is of sufficient complexity that more formal motion practice was required, and cite Hollop and this particular paragraph in Hollop for that proposition. And it works both ways. If you're the prosecutor and there's some kind of crazy motion, you would address it this way. Alternatively, if you're defense counsel and the state makes some kind of crazy motion, again, orally, and you're objecting to it, you utilize Hollop to require your adversary to follow more formalized procedures.